We'll now start our technical session 2 on emerging issues in regulation of combinations. We have as session chair Mr. Bhagwant Singh Bishnoi, member CCI. Mr. Arijit Burman, Deputy Resident Editor, The Economic Times, is the moderator of the session. We have a very distinguished panel. I'd request Mr. Burman to introduce the panel and start the session.
Good afternoon, everyone. It's a post-lunch session on Saturday afternoon. So I'm sure most of you would rather be home than attend a conference, but we'll try to make it as riveting as possible because the subject indeed is one. Now, we've been told historically, or as the popular saying goes, that marriages are made in heaven. But in today's world, where even currencies are getting stored in databases known as chains, which in turn are connected through peer-to-peer nodes. I'm talking about cryptocurrencies, and all of us are soon going to have a digital avatar in metaverse. Marriages, at least the corporate types, are increasingly getting consummated in boardrooms, precipitated and catalyzed by private equity or venture capitalists who have more money, certainly, than the gods. Therefore, our topic, emerging issues in regulation of combinations, becomes very, very relevant and topical. We are seeing a spate of interesting, transformative, even disruptive mergers and acquisitions take place across the digital and tech ecosystems. Even in legacy sectors in infrastructure, for example, ports, airports, and of course, green energy, we are seeing a lot of consolidation. Green energy, of course, is the color of this ESG season. But before we get going, I would request Mr. Bhagwant Singh Bishnoi, Member, Competition Commission of India, to say a few words and inaugurate the session. Over to you,
Thank you,
Mr.
Arijit. Eminent panelists, distinguished guests, it is indeed a pleasure to welcome all of you to this event today, which is part of the Azadi Ka Amrit Mahotsav or AKAM celebrations. We are grateful that we have the opportunity today to showcase the work of the Competition Commission. While the audience today is the most informed one, it also so happens that the public at large remains uninformed of the work that we do. So we are fortunate that a program this morning was inaugurated by Minister of State Rao Inderjit Singh Ji. That was followed by a session on the antitrust enforcement part of our work, which was chaired by my colleague, Dr. Sangeeta Verma. We now have this session on the regulatory aspects of the Commission's jurisdiction, where we deal with mergers and acquisitions. Our general approach is regulation with a light touch. A journalist I met this morning explained to me that the light touch is the reason why we do not get the media attention which we might get otherwise. Be that as it may, I do not think that any change is warranted. In fact, just the other day, our minister highlighted that regulation with a light touch is what she expects from us. Ladies and gentlemen, we are fortunate to have Mr. Arijit Burman as our moderator today. He is, as we all know, most competent for the job, given his wide experience in covering the areas of mergers and acquisitions. To complement Mr. Burman, we have an illustrious and diverse panel comprising of officers of the CCI, legal practitioners, industry representatives, and economists. This, we expect, would allow for wide-ranging discussion from multiple perspectives to get a 360-degree insight on our work relating to combinations. This is one of the first conferences in the physical mode in the post-COVID area for CCI, and I'm happy to see so many bright and happy faces here. COVID has brought about several disruptions in the economy and supply chain. It has also changed the way goods and services are delivered, and some of the new modes seem to have acquired permanency. It is also generating ideas and innovation. We are witnessing growth in the startup ecosystem and new opportunities for investment. Keeping pace with the changing economy, the M&A landscape is also changing. New trends are emerging, especially with regard to transactions in the digital sector and investments by private equity and institutional investors in the new economy. Given the fast evolution of new markets, the challenge before competition authorities is to stay ahead of the curve and be agile in identifying and addressing competition concerns. Agencies also need to craft suitable remedies for effective market correction. It is therefore important that regulators engage with stakeholders to understand market realities and challenges and use the feedback to improve their practices and processes. In the last 2 years, we have taken several steps to make the filing process easier. I will mention a few. We have simplified the forms for notifying a transaction to the Commission. The objective is to reduce compliance burden so that we have timely disposal of cases. Electronic filing has also been introduced, with parties being allowed to file notices and pay fees online. The Commission has done away with the requirements for filing details of non-compete covenants. This allows parties greater flexibility while negotiating transactions. The average time taken to dispose of a combination notice has come down to 17 working days. The Green Channel scheme, which was introduced in 2019, provides for automatic approval of certain combinations. It has gained traction, and 55 cases have so far come via this route. In the last financial year, 1 out of 4 combination notices filed was through the Green Channel. The challenge for the CCI is to keep pace with changes in the business sector and adapt quickly to new requirements. The fact that our regulations have been amended regularly shows our commitment to being responsive to the needs of the market. Our overall aim is to further strengthen the trust-based regime, which is the bulwark to maintain the fine balance between enforcement and facilitation. With these remarks, let me once again welcome and thank all of the panelists and participants. We look forward to a productive session. I thank you all.
Thank you, sir, for setting the agenda. Let me now introduce the panel to everyone. Avantika Kakkar, partner Cyril Amarchand Mangaldas. Mr. Ramesh Subramanian, till recently Senior Vice President of Tata Sons. Mr. Roshan Thomas, Group General Counsel from EdTech Major Byju's. Mr. Ramji Tamarapo, Senior Economist, Eon One Research. Karan Singh Chandiok, Partner Chandiok and Mahajan. From CCI, we have Mr. Manish Govel, Advisor CCI, and Mr. Vipul Shah, Joint Director CCI. Thank you, everyone, for joining this session. My name is Arijit Barman. I work for the Economic Times as a senior editor, and I will be moderating this session. Some housekeeping rules I think we should set before we actually begin. We shall try to keep this session as interactive as possible, so anyone, if you want to disagree with a point of view, please, butt in. Please agree to disagree. After all, we are a boisterous democracy. If possible, keep your answers non-technical so that a layman like me also understands. And at the end of the session, we shall open the floor for questions. So let's dig right in and start by a rather macro question. Amalgamations have become pretty common these days. It's a commercial call. Private equity sitting on $3.4 trillion of dry powder, a third of which actually sits among buyout funds around the world as per our latest study by Bain and Company, the consultants, private equities have really become a mega force to reckon with. Parallelly, we have also seen the speed at which several conglomerates, like an Adani, like a Reliance, are shopping for assets and companies in India and around the world. But my first question, and that will be to Vipul, do such widespread consolidation by either private equity funds or concentration of power and clout amongst a few strategic companies lead to lesser competition? What's the regulatory point of view?
Thank you, Arijit. In my response, I'll try to balance all the pointers which you have given us, including the language which should be, more general. And I also try to have more of the discussion in the most conceptual of the terms. So, though the question has been posed in terms of the private equity and the concentration arising therefrom with their operative framework, I'll try to generalize the same by saying that the major concern is the issue of common ownership and cross ownership, if we put it in more general terms. By common ownership, we would mean that some operators are acquiring equity stakes in most of the competitors which are operating in a sector. Another trend which has been associated with that is that generally the acquisition of stake would be minority. Instead of going for full-fledged acquisition, merger or amalgamation, there would be a trend of acquiring a minority stake in a number of competitors. Similarly, there can be trends of cross-ownership as well. In that case, the player will not be a private equity player. In fact, it will be an operative competitor in its own right, but it's also investing in another competitor. Now, what happens in this kind of ownership structures and this kind of acquisitions is that, yes, there are definite chances of softening of competition, because either the institutional investor, if it is a case of PE investment, or the competitor who is going for cross ownership will definitely have, number one, different set of incentives. Secondly, it will have different set of ability as well. There may be chances that the person with its clout, with its power, is able to influence the unilateral decision making, or may simply use the platform of these many companies for coordination of their actions. So there are definite theories of harms. The theories of harms are being developed. These are the concerns which are being voiced all over. Now, is it a matter of concern? Yes, it is a matter of concern. Second question, is our regulatory landscape equipped to take care of these situations? So now on the second question, I'm going to give you a brief overview of the regulatory landscape in India. See, let's begin from the very basic question. What are mergers? Mergers and acquisitions basically denote economic integration. Economic integration which is going beyond the ordinary commercial linkages. So there is something more. Instead of a purchaser-supplier relationship, there is something more which is being added. Now what is that more? This merger and acquisition activity can take various forms. It can be outright mergers, amalgamations, or it can simply be acquisition. And when it comes to acquisition, again, it can be acquisition of shares, acquisition of voting rights, acquisition of assets, or acquisition of control. Now, what is the significance of these different forms? How should we consider it? How do we consider it in our regulatory framework? It's very important to have this classification. These different forms of mergers and acquisitions are associated with different degrees of integration. In case of mergers, amalgamation, acquisition of control, the integration is likely to be complete. And in case of acquisition of shares or voting rights, it may be complete or it may be partial. Now, this brings first question, which is to be addressed by all the jurisdictions. I'll tell you what have we done in CCI. And the question is that what are the instances which you are going to regulate? Are you going to regulate only the cases of complete integration? Or are you also going to regulate the questions of or the issues of partial integration? The competition regime in India is a check-all approach, and we consider all different forms of acquisitions, even if it is a partial integration, into the fold. But there is an obvious flip side to it. And what is the flip side? If we are going for this type of an approach, there is likely to be a situation where the number of combinations which require to be notified can be many. So how are we going to bring in that balance? So what CCI has done is, CCI has carved out an exemption as per which if there is a minority acquisition, less than 25% of shares, and if that acquisition has been made in ordinary course of business or solely for the purposes of investment, then that particular combination is not required to be notified. Through its decisional practice, we have clarified what is meant by ordinary course of business. We have given an explanation through our combination regulations that what constitutes solely as an investment. So basically what we are trying to do is, number one, to appreciate that yes, there is a concern which implies that such acquisitions are required to be examined. Number two, putting up a framework for examination of such combinations. Number three, ensuring that such framework does not cause an overreach and goes into the combinations which do not pose any harm to competition at all. Mm-hmm. I think this sets the tone for the discussions.
But Avantika, you are a practitioner of law, so what are the real issues? I mean, Vipul explained the lay of the land, but when you're dealing with clients, when you're dealing with real life situations, what are the issues that you face within this framework that Vipul just described?
Right. I think I have to say I disagree with Vipul on common ownerships being a concern. And the reason I'm saying that is that I'm not sure that one can definitively say that there's any empirical evidence to suggest that common ownership does in fact lead to a lessening of competition. It could. But does it absolutely in every case lead to a lessening of competition? I think instinctively I would say no. Having said which, it's also not a concern anymore because we have to understand that India, the regulator in India often has to explain its stance on minority acquisitions, but in truth it is not the only regulator that requires the notification of minority acquisitions. So who are the other jurisdictions? There's UK, there's Germany, there's Austria, there's Japan, there's the US in some cases, and there's Brazil. So I don't think the Commission needs to justify the fact that it is going to examine minority acquisitions, even by private equity players. That I think is now very clear. There's also ample clarity in the nature of transactions that they will examine. But on a practical standpoint, when you are writing the form for the Commission, you have to understand that a private equity player does not necessarily always get involved with the business. The private equity player does not have access to the information that is sometimes required on the portfolio that you require. A private equity player could be a fund of funds. It could be an investor in another fund who in turn has portfolio investments. It does not have access to the information that is required in the form that we file. Now, practically, this is overcome because we do get the requisite, the request for information from the Commission, and we are in most cases able to explain this away. But that's the practical glitch. It takes time to explain this to the clients who you're coordinating with. But I think there's also a high degree of comfort now within the Commission that, okay, if they're saying they don't have the information, then they probably don't.
But isn't it more nuanced in the sense that when you say private equity, you're calling them passive capital providers, but many of them are increasingly becoming more proactive. They are becoming far more micromanagers, so to speak. So therefore, they're just not a capital provider, they're much more than that.
Which is why they're not exempt.
Okay.
So we don't go with that underlying assumption that they are naturally passive. Most private equity players will say we are passive investors. But the Commission, with its precedents and with the way it enforces these precedents, does not take that assumption on face value. It digs deeper.
And you also talked about so far we don't have empirical evidence about concentration of clout or power. isn't that the big global debate today when it comes to, we'll talk at length about it, but big tech and breaking big tech, or, the way AT&T or big oil, was broken up. We do seem to have some evidence, even as consumers in India, that many of these platforms do actually have a lot of clout and influence and impact our behavioral or consumption patterns.
Right. So again, I think clout, influence, dominance, being big, these are not illegal. Yeah, definitely not before the Competition Commission of India.
Mm-hmm.
But yes, the exercise of an influence which could be abusive conduct, it is being investigated. I think the debate is on, as you rightly say, but I don't believe, other than case-by-case action, the world has moved much towards anything harsh, because I think everyone is mindful of balancing the need for innovation and balancing the need for everything else, that is, a level playing field and fairness.
Mm-hmm.
So I think a lot of the large investigations that are happening, the famous GAFA investigations, which are also now picked up in a very big way in India, these are all steps towards that regulation. But I think the fact that you're being investigated doesn't necessarily make you bad till that investigation concludes.
Right. Roshan, we're talking about big players. Byju's is certainly a very large and influential edtech company. It has grown through acquisitions, not just in India, even overseas. Now, many of them would be great or value accretive for your shareholders, but there seems to be a creeping apprehension among certain stakeholders that it may not necessarily be so for the wider ecosystem or the edtech ecosystem. How would you react to, such views?
Thank you, Arijit. Soften that one. No, thank you. I think, as a responsible industry player, we welcome regulation in the space. And we, in fact, had recently the opportunity to be interacting with the CCI on a deal, the Akash merger. And at the outset, if I may say this, if that interaction was anything to go by, industry has nothing to worry about, because the process was efficient and pragmatic. So, we approached the commission about 2 weeks in advance of the filing for a pre-filing consultation, or a PFC. And the constructive feedback that we got from the case officers helped us identify data gaps well in advance, also get a sense of what it is that the commission's actually looking for, so we could tailor our form to address those concerns. This is an invaluable process, because one of the concerns we would have as industry is, are you going to be hamstrung in being able to close a deal, because it's going to take an extremely long period to address markets that are not commonly understood, or new markets, new emerging markets. And that PFC process was invaluable. Similarly, I think just in terms of the attention and responsiveness we got from the commission, and I know this was at the height of the pandemic, several of the case officers were dealing with health and health issues, but yet I think we got through the entire process in less than 45 days, which is fantastic. I mean, again, from the industry's perspective, are we worried about, being part of a process that's efficient and pragmatic? No, we're not. I think definitely happy to be part of that. And similarly, I think the way the commission approached the definition of market, they kept it open, as rightly should. They analyzed the parties' definitions of what is the broader market, informal, non-formal education, and then narrow markets, which is specific test prep, to come out with their assessment. So this demonstrates, again, pragmatism, sophistication, and readiness to understand emerging markets. You need that practice to be able to give us comfort, to be wanting to be part of a process.
And how has been the experience overseas as well? Because you've acquired companies in other jurisdictions as well.
So all of them were luckily exempt. That said, okay, sorry, I have a quick comment on the private equity piece, though.
Yeah, sure.
I do think that overregulation of minority investment protection rights is going to be problematic, especially in this market, this macroeconomic climate where capital raising is so challenging. Companies are going to struggle to be able to raise money.
Not by Jews.
We're an exception maybe, perhaps, but generally. I think it's important because as responsible investors, the private equity investors, they have fiduciary and legal duties to their own investors, their sources of fund. They need to make sure that the money that's going to a company is not being frittered away. It's actually being utilized for the purposes it was meant to. So therefore, a board seat or control in terms of consent rights over, changing business lines or approving new forms of business models need to be given, because that's where the money came for. You can't just now suddenly say, I'm a mobility company and I'm going to turn around and do restaurants the next day.
Can I add?
Yeah, please.
Actually, if you look at from the private equity world perspective, most global private equity are very scared of being on the wrong side of competition commissions across the world. But look at their commercial motive. The commercial motive is to have investments in a sector. And for India is part of the emerging markets segment generally in the private equity world. And therefore, their intent is actually to grab the sector. Their intent is never to kind of go deep into the markets and become one large dominant player. They want in many ways, diversification of risk. So if they enter into one sector, they would like to invest in 2 or 3 companies, one with a focus on something, one with a focus a little better, to hedge the risk. Sometimes the intention is completely devoid of even having an idea of having control or trying to dominate the market. So I think most investments will qualify under that. They are more for hedging risks against each other, one company management versus the other, and one segment leader versus the other. So I think that's where I think this minority interest, I do agree with Roshan that sometimes this is slightly, I think, the worry is much more than it is actually. Maybe in some cases there is a definite intent to have a grand plan, but most private equities have first of all, they have limited lives. And if they have limited lives, their immediate worry is to get out with the maximum valuation. And in that space, a fund tries to maximize the return. Its intention is not really to look at long-term market creation, etc.
It's true, Mr. Subramaniam, for, I guess, private equity funds to diversify their portfolio, but in venture capital, it's a little more different because they do have competing businesses in the same portfolio. But, the spate of digital M&As that's happening all over the world is forcing antitrust authorities to focus on 2 things. One is, of course, the size and concentration. A large number of acquisitions by the big tech firms are perhaps also to kill potential competitors that are nascent, yet strategic in terms of the IPs they hold, which could be disruptive, or they have access to consumer data, which we all know is the new oil. Remember, ages ago, Coca-Cola bought Thumbs Up and Gold Spot, and then Gold Spot vanished from the market. Coca-Cola, however, couldn't kill Thumbs Up, though. It still is the #1 cola brand in the country. But as an economist, Ram, how do you see this play out? You come from DC, from Washington, DC, and there the regulators are talking really tough these days.
Thanks. So I think we need to understand what we do when we talk of a merger assessment. So it's essentially an ex-ante assessment. So we have to imagine what the world would look like after the merger or acquisition has happened, and then see what sort of anti-competitive behavior is possible. Right.
Sorry to interject. So ex ante, you mean you're forecasting
Yes.
before the actual event?
Exactly.
Yeah.
Right. As opposed to the morning session, which was
Yeah.
enforcement, which is an ex post analysis.
Yeah.
So in this context, traditionally what we do, and when I say traditionally, the industries prior to the digital revolution, to simplify the matter, we had a structure, or we still have a structure where we say, okay, what are the contours of the market in which the two parties operate in, right? The products, services, as well as the geography. And then once we have the contours of the market, which is called market definition or the relevant market, we then say what is the overlap between these two companies. And then once we know the overlaps, we then go into a deeper assessment to say, within these overlaps, what is likely to cause anti-competitive behavior, right? So we look at what is the market share and market concentration prior to and after the merger or acquisition. Are there any entry barriers into this market? What is the nature of buyer power in this market? Do they have countervailing power? Are there substitutes for these products? Are there imports which would constrain the behavior of these parties? And is there a scope for what we call unilateral behavior, which is to raise prices, reduce production, or any kind of cartelization, which is cooperative behavior between competitors? So this is the traditional approach that we take. Now, with digital markets, this whole paradigm has shifted. And so what we have to look at here is the relevant market analysis even practical or applicable? I'm not saying in all cases, but in some cases, right? And especially if you're going to look at what is going to happen post the acquisition, we should focus on the market in which the companies are going to operate after the acquisition. So for instance, if you look at the big acquisitions which everyone talks about, and which is, again, in Washington, D.C., spoken about a lot, is Facebook acquisition of WhatsApp, Facebook's acquisition of Instagram. When you look at Facebook, it's a social networking platform. WhatsApp is a messaging platform. Instagram used to be a photo sharing platform. So
it's getting blurred.
It's very blurred. So, one, you can say, because technology or digital technology is pervasive and is the backbone of a lot of different products and services, one could say, well, everything belongs in this market. I mean, which is not really useful because you're just expanding the contours of the market and you're not going to get any meaningful results out of it. Or you could be very narrow. And in that case, and that is precisely what happened with WhatsApp and Instagram initially, because those mergers were not challenged by the Federal Trade Commission, and it went through. Because the market would have been social networking, photo sharing, they're not in the same market space, there is no overlap, no cause for concern. Now, what happens in digital is you could have adjacencies like this, or it could be a completely unrelated. For instance, Amazon, which is e-commerce mainly, went and acquired Whole Foods, which is a food supermarket chain, right? Then everyone is talking about Tesla acquiring Twitter, right? One is e-car, e-vehicle, autonomous vehicles, whereas you're talking about another social networking platform.
Amazon bought Zoox, right?
Zoox,
which is also an autonomous vehicle.
Exactly, right? So these are, again, how do you even do a market definition and an analysis in this situation? So the issue here is really focusing on, if we can, what is the market that the companies, by merging, what synergies are they trying to unlock so that they can enter into another space where they might already be other market players, but they could use the power, the synergies, and probably become a bigger player in that market, or to go into a completely new market or create a new market in which they will be the first entrant, and obviously there could be potential entry barriers which could be raised so others cannot enter. Right? So these are some of the issues in terms of digital markets that are very different from...
And evolving.
And evolving. And so my approach to this, and which is, I guess, the way in which, there are a lot of academics talking about it, is the way in which I think enforce or regulation of mergers is going to go, is actually identify, if possible, which market these entities are going to play a role in, and do what we call in our profession as an effects analysis. What is the effect, economic effect, rather than focusing on trying to define a market and coming up with nothing, right? So you might as well take a practical approach and look at what the effects are in the new market, which, again, that's a guessing game. You never know, which markets are, especially in technology, where there is a lot of innovation. The direction in which the markets evolve is completely unknown, right?
Karan, sitting in New Delhi, far away from DC, but some of these issues of concentration are universal. I mean, we are also talking about it, for example. So how do you guys, as lawyers, assess concentration when market boundaries are so fluid? As Ram was saying, a search company getting into advertising, Google, Facebook buying WhatsApp. WhatsApp's a messaging company, Facebook was a social media company, Microsoft buying LinkedIn. And there are numerous such examples. So as practitioners of law, how do you really, break it all down when things are so fluid and so still evolving?
So
in an India context.
So speaking from an Indian context, Harshit, I think the main aspect is, so when we're applying the foundations and the framework under which we work in is established under the law itself. And as Ram was mentioning, with the boundaries of the relevant markets, the markets in which the concentration is going to have an effect, are also defined, and that is the job when we go in as lawyers, when we present to the commission to say, here is my transaction, please look at it, is to go and say, this, according to me, should be the relevant market. And the commission may agree or disagree. I think Roshan mentioned that when they went for the PFC, maybe the commission had a different view on the way they perceived the market to be. And then you address it on that basis. But I think what your question is a wider question. Do we need to have a policy and a regulatory response to sort of this market concentration? I think as a very fundamental level, should we today stop entrepreneurship? One is I have a core business area that I do. I am a cab hailing app, but tomorrow I think there is a business in making motorcycles and scooters in electric motorcycles. Should I be stopped? Should I stop that entrepreneurship? Should I stop that economic growth from taking place? And the capital behind that works towards it. The second is, do we have today evidence that this has been bad? Yes, Facebook and WhatsApp did bring out a regulatory response to say, do we have the tools currently to even scrutinize them? Because we want to scrutinize this before it happens rather than afterwards, because perhaps markets would have changed so dramatically that the changes in the market would have been irreversible at that point. But the tools are still there. We have in the Indian context Section 3 and Section 4, which deals with abuse of dominance. So the CCI as self is not without any powers to look into these issues. The second thing is what is evidence telling us? I mean, as lawyers, the first thing I look for is evidence. Prove me this conduct led to this effect. But if I look at, in fact, the authority in the UK, the CMA actually commissioned a study into some of these large transactions that had taken place. And I'll take two examples. One was Facebook and Instagram. And when Instagram started, the acquisition took place, they were at about 30 million users. But post-acquisition, they went up to 1 billion users. At that time, it also allowed Instagram to evolve as a product. It went from a photo sharing app to a messaging app to a social media app, allowed it to monetize it in ways. Today it has reels and the likes, which were product innovations which were otherwise not there. So it reached a larger set of consumers. It became a better product. And that is what this study actually said, that because Facebook had these R&D efficiencies, those efficiencies were leveraged and made Instagram into a better product than it was previously. Equally, you look at, that's perhaps still somewhere in the boundaries of social media, right? You look at Google and Waze. Waze is, Waze is a map, as a There's a map app which tells you live traffic data. Now, the way Google and Waze approached the market was very different. Google Maps did licensing of satellite technology. It had its, those Google cameras going around the world and taking street views. And Waze did it by crowdsourcing. You and I would say where the cop is, where the traffic is, and so on and so forth. But when the Google Waze transaction took place, again, the CMA examined the fact that they were actually complementarities and efficiencies, which made both of them a better product, which meant ultimately consumer welfare actually was enhanced. So unless and until there is clear evidence that these are going to cause a grand plan, as I think one of the commentators said earlier, unless and until that is there, the regulatory response should be the light touch, which Member Bishnoi mentioned. Mm-hmm. And the way the response has been outside India, and I would say less so in India, but outside of India, is that when you go in for a scrutiny of a transaction, you're asked for now immense amount of data. You're asked for, okay, the deal team, I want all their emails to be put forward because they want to know, was there a grand plan to begin with? And most of the time, the answer is no. We don't perhaps do that so much in India, but that is the thinking behind it, to see, is this speculative or is there something behind it at all?
Mm-hmm. So Ram, it's really boils down to a very tough balancing act. Killer acquisitions versus where the potential benefits from the M&A, as Karan was saying, could be significant due to the spillover effects or, somebody leveraging, the R&D capabilities of the acquirer. And the spillover effects for consumer and society at large. It's really a tough balancing act.
Yeah, it is. I mean, all merger control is, like I said, because you're dealing, it's a lot of crystal ball gazing with, some information which you have. So especially, when we are talking about digital markets, the balancing act there is like, what was highlighted in the panel's discussion earlier today, is to err on the side of caution, right? So that's what we call type 1 error, right? Mm-hmm. So you, actually that's not type 1, that's type 2. But so type 1 error is where you disallow a merger, assuming that it is going to be causing anti-competitive effects in the marketplace, mm-hmm. right? And as opposed to a type 2 error where you actually allow a merger, but in fact it should not have been allowed, right? Because it potentially has the anti-competitive effects. Mm-hmm. Now, in the case of in technology markets or digital markets, type 1 error is more costly because you're potentially saying no to a transaction which could actually lead to greater innovation, technological progress, and more consumer welfare, mm-hmm. right? If you wrongly disallow a merger, then the cost to the economy and the welfare costs are pretty high. On the other hand, so there you would want a light touch, meaning you don't want to commit a type 1 error, so you actually be more lenient when you're assessing a merger when it comes to technology or digital marketplace, which we don't know much about. Mm-hmm. But on the other hand, when you allow a merger, and it happens to be a killer acquisition, where the company decides after the merger not to pursue the idea of the target. So in that case, the type 2 error becomes costly when actually the target could have led to greater innovation and new products and services in the marketplace which enhance consumer welfare, mm-hmm. right? So again, it's very difficult, but given that killer acquisitions, there is not a whole lot of evidence of killer acquisitions, at least as far as we know. It's better to actually minimize the type 1 error, meaning have a light touch, assessment, merger assessment. But again, like as Karan was pointing out, there are sections 3 and 4. If something goes wrong, then you have the tools to actually do an ex-post regulation or enforcement when there is an anti-competitive behavior that is being spotted.
Got it. Mr. Govil, I'll want to bring you in here and ask you, based on what Ram and the other panelists are saying, do we then need
It is placed before the commission. The commission takes a concerted decision on those mergers, and an speaking order is passed, and that speaking order is put up on the website for public viewing, except for some confidential information which is masked. Most of the order is put up before mostly all the orders are put up before the public, and it is also appealable also. So it's all a public process. So we have to make sure that these are legally sustainable orders also. We have to follow the due process of law. So that is the third challenge. So having said those challenges, we are constantly in this endeavor to meet up with these challenges at the commission, and we interact with the stakeholders and the lawyers. All of us are in this whole process of how to make this process more efficient, more simple, more quicker for the parties, for the general parties in general. Now, having said that, coming to the next question which Arijit has put, that do you need certain, do we need other ex-ante regulation? That's a point to be debated. We had a e-commerce study recently, some 2 years back, and in that e-commerce study we had recommended for self-regulation of the industry. In fact, a lot of session previously also, many of the people have said that there should be self-regulation in the industry. But if the industry does not self-regulate, and if there are still concerns, then there have to be some soft type of regulation which have to come into place. Like, for example, in the EU, they have come out with a new competition toolkit. So it's a series of ex-ante regulatory, what you call, commitments which these big companies have to undertake, a sense of behavior against their partners, which they have to take, and that is in the public domain. So those type of issues we'll see. The time, I think, may be ripe if we are not able to what you call regulate the industry through these soft touch methods which we have in the Competition Commission here. Thank you.
But Vipul, in our laws, we do have section that allows for breaking up of companies. I mean, section 28 to be specific, yet to be tested, but we still have it.
Yeah, we do have that section, but before we go into it, let me respond to a few of the points which have been made regarding the relevant market and the assessment framework which can be followed in case of digital mergers. See, what I believe is that what is relevant market? Relevant market, as defined under the Act, as generally understood in context of antitrust or merger regulation, is basically an attempt to bring in the products which are related to each other. Now, there can be different aspects based on which that relationship can be established. We generally consider it in terms of demand side substitutability, and we consider the factors such as characteristics, intended use, price. There are jurisdictions who do factor in the supply side substitutability as well. So relevant market does not have a proper, or you can say, a very limited or restrictive application. Now, when it comes to the digital markets, I believe some linkages can still be explored, evaluated between the merging parties. Yes, there can be some situations in which the parties who are merging may be in completely unrelated areas, and we are not able to find any parallel between the operations of the two. And in some cases, there may be some linkages. For example, we always talk of data as being a link for most of, or data being a link or being a driving force behind most of the digital mergers. So that may be one way to settle the relevant market issue. I really believe that the problem is more on the issue of evidentiary standard in terms of theory of harm. when we associate technology and when we say a new technological innovation being made, it sometimes surpasses our wildest imaginations. We couldn't have imagined that this type of product is going to make way, and suddenly we see a new entry in the market which is in that zone. So that means if technology is capable of making such big leaps, then the examination of a merger, when you come across certain aspects on which the competition authorities may believe that, combining these type of R&D technologies, combining these type of data analytical technologies, etc., can actually lead to development of new potential products, which can turn out to be a sort of a killer proposition or, a sort of a foreclosure proposition. The evidentiary standard in terms of those theories of harm may not be very strong. But it is not because of any weakness in assessment, but because of the very characteristic of technology leapfrogging itself. So I guess some debate has to, we have to have some debate on what kind of evidentiary standard we are looking at. Then a point was made by Ram that, we should be more acceptable of type 1 error. I would say that in case of technology, the resulting situation may be such which may be impossible to revert. If you find that you have landed up in a situation where foreclosure is imminent, even if, now I'm coming to the section 28 aspect also, though it is untested, but even if we go into that domain, every application of section will have to have a developed framework, how you are going to apply it. It is definitely going to involve time. Now, time being the essence here, the time which is taken to complete the investigation in itself can be enough for the person, for the parties to move on to the next product, or even if they continue to hold the existing product in the market, it may not be of high economic value to them. They might have, already found out the alternatives for which they are going to move on. Secondly, even if section 28 has that force, let's first discuss what are we going to divest. When we speak of remedying a merger, what do? We either go for structural remedies where we may be asking the parties to divest. It generally is going to function more in case of manufacturing entities, traditional entities, where the capacities will be divested. Behavioral, given the algorithmic usage, given the way the digital markets function, behavioral remedies are not going to work. So what exactly are we going to achieve with divestiture? So if the divestiture being that difficult, and the divestiture, not being economically viable also. So don't you think that in such situation, even the type 2 errors do come in, that it is important to prohibit or, remedy the mergers at the inception itself, and the debate can obviously be on the required evidentiary theory.
You talk about divestiture. I mean, two big case studies in India was the Lafarge-Holcim merger, and you asked Lafarge to divest their plants in eastern India, and L&T Schneider, where CCI put a lot of conditions. But many would argue that these cases are few and far between. Is that exactly the reason why it is so?
Actually, that to some extent is a testimony of the kind of merger assessment that is done, and the cases which actually require remedies are far and few. Mm-hmm. Now, apart from Lafarge and Holcim and L&T Schneider you mentioned, there have been other cases, but most of the cases have involved manufacturing operations. So, those have been traditional, conventional industries where the capacities have been divested. Where it was felt that divestiture may not be required, then the behavioral remedies have been resorted to. But this is an indicator that the assessment do factor in all the possible perspective from the business side as well, and the remedies are imposed only in the cases where they are earnestly required to remedy the situation. So that's broadly in line with the international trends as well.
Correct. Now, most people would say that we look at product market share to make a decision. But as the panel, a lot of members have been saying, and it's a reality as the lines are getting blurred, fintech or payments is becoming an integral part to many of these corporations. Now, does the dynamics change completely if you add a product market share with payments thrown into the mix? Like Google has payments, so when Google does something, you not only look at product market share, but also look at what the implications are when you add the payment side of it to it. Similarly, Flipkart now has a fintech side. Several other such companies and conglomerates have that. So does it add a layer of complexity as well to when you judge these cases?
I'm taking payments as basically any other conglomerate product, which may be applicable in that situation. This is also an increasing trend, which have been witnessed. The core reason for it may be that the firms are opting for diversification. This may be a very big justification from the business perspective. But from the competition law perspective, again, if we consider diversification in traditional space, it will have some ramifications. And if we consider diversification in form of such acquisitions in the digital space, it will have even more, different ramifications. Yes, any kind of diversification adds a layer of complexity to the analysis. And the reason is that most of the theories, the developed theories, will speak of unilateral effects, coordinated effects, and those are applicable primarily to the horizontal overlap cases. In case of vertical mergers, again, the theories are very clear. We are going to look at the ability of the parties to engage in foreclosure. We are going to look at their incentives. And based on that, we will be in a position to arrive at some sort of decision.
Good.
But when the products are neither horizontal nor vertical, then as we were discussing in case of digital, they may have some linkage or they may be completely delinked. In case they are completely delinked, then it's fine. It's very hard to find any plausible theory of harm associated with that phenomena, and the only reason can be diversification. But if there is some linkage, then the complexity, will increase manifold. And again, the focus will shift on delineation of relevant market. As I discussed, that issue can be handled to some extent. And again, the crux will come to the evidentiary standard for the theory of harm. Because you do not want to come across as very speculative. When you say, A and B are merging and we believe that this is going to happen. So it shouldn't sound like you are reading a sci-fi novel. That, this may happen, that may happen. Obviously, you want it to be grounded. You want it to connect to some of the case facts. But there is going to be a limitation.
But some of these innovations are like sci-fi.
Exactly. It is like, that's what I said. So, when we are looking at that situation, when our focus is completely on the future, we are not even concerned that what their current products are. They may be completely unrelated. So when we are completely looking at it in terms of the potential competition, in terms of the potential products and services which they are going to offer, then, we have to apply the evidentiary standard and the theory of harm in that manner. That's my take. But what can be the reasonable connection between the current state and the envisaged state? That is something, which is an open question.
Avantika, we are talking about, these disruptive innovation. We're talking about, technology companies, consumer internet. But we have also seen these killer acquisitions in the past in pharma and biotech, which of course also involves a lot of innovation, R&D and IP. Isn't that so? Have you ever dealt with such cases and what's been your experience like?
I haven't dealt with killer acquisitions in the pharma space as such, but just jumping off from where Vipul left off, the Commission has seen innovative markets, and my experience has been with the consequences of what economic and legal theory have called killer acquisitions. So we all know that in the pharma and biotech space, as you rightly say, they have happened in the past. What has the consequence been? The consequence has been that competition regulators worldwide examine pipelines, right? So when parties go and report a merger, then they have to report the products that each party delivers, manufactures, sells, markets. But there is a specific question on what's the pipeline. And I think one recent case that the Commission worked very long and hard on, and I think some of the representatives are here as well, and I represented a third party there. This was the ZF and WAPCO transaction. And that is where this novel complementary market definition became very key, because the two players were auto component manufacturers. And the argument usually would be, if I were to go in with a notification to the Commission that I make brake cables, he makes brake cables, look at our combined market share. But what do you do if you only make separate components of what we call the braking system? So I think the Commission's order is actually a very beautiful read on system markets. And the Commission found that you don't necessarily, they found the middle path between horizontal and vertical linkages. They said there is such a thing as a complementarity, as a system linkage. And you could be suppliers to a braking system. And here also they applied, they brought into application the innovation theory of harm, where there was an expectation, there were pipeline products in the drum and disc braking system spaces for commercial vehicles. And the Commission said, no, we are not going to let the transaction go through without remedies, because we anticipate that the incentive to not allow innovation by a joint venture partner will be high. So the remedy was that incentive is done away with. So again, linked to killer acquisitions, I think they can come anywhere. I think in the future, a lot of the discourse is around renewable and sustainable energy. You might see killer acquisitions there, because a lot of innovation is happening in that space as well.
Yeah. But the other narrative vis-a-vis killer acquisition is small target exemptions. Mr. Subramaniam, thank you patiently for waiting for so long. I wanted to ask you, should lawmakers consider revising the structure of the small target exemption and allow exemptions only if both assets and turnover are below the threshold, instead of the current practice where the exemption is allowed even when the value of either of them does not cross the threshold? I'm asking this because we've seen, one of the recent transactions, the PVR-Inox merger, did raise a lot of eyebrows in this context.
Yeah, but I think I'll just probably give a few pointers to what could be the change that's required. See, first of all, most acquisitions are only ambitious plans, and many of them do not really fluctuate to the extent they are intended to. So many of the acquisitions have not really resulted in a major loss to consumers, and that's a study which is already, several studies have been done to prove that. So I would really err on the side of light touch approach on that. The second context is that if I were CCI, I would take the risk of allowing, let's say, more support to efforts to bring in superior products to the consumer than worrying about the effect on the markets, which in many cases are not visible at the time of the acquisitions. This can happen much later and may not happen also. Now, the current definition, for example, and I'm told that there is an effort to even revise this or review this definition by bringing in more measures like value of the acquisition itself, which again, I think we are moving, if you do that, then you move away from the whole issue of market and consumer. Value of the acquisition is a matter of profitability and also sometimes asset base. If you're buying a power asset, then your value of acquisition will be very large, but profit you will not make much. So there's no relevance to that also. So if you put all this into context, and I think the principle should be then that whatever is really small, and really small from the fact that it can be detrimental to consumers, that should be filtered out. Now, the current definition, it says exemption is for those having either lower than 350 crores of assets or lower than 1,000 crores of revenue, means that many, actually I'm talking probably contrary to what the industry would love, to have loopholes. But I think what we are trying to do is I think the current definition allows so many acquisitions to go away, go under the carpet, that you will have to think about something new to be strengthened. Instead of that, the simple solution could be, if you say, if you really want to filter the big acquisitions, then maybe you can just, instead of or, put and you say that, if you're both large on revenue and large on assets, then you qualify to come to us. You're not going to be exempted. So I think we've probably created a problem which you're going to solve by some other means. I would say don't even look at the other means. Just solve the problem by probably thinking a little bit on what the current definition is. That could perhaps solve the problem. Because, for tech industry, for example, you are acquiring companies which have no revenue turnover right now, very few assets, because they require only people largely and software. So there, it's very easy to bypass these criteria. So I would rather be worried about a regulation which inadvertently hits other acquisitions where there is no real concern in the name of trying to solve one problem. That's the only issue I may have with the current piece.
Karan, as a practitioner, you want to come in and add,
So I think a lot of my clients will kill me for saying this, but I think I fully agree with Mr. Subramanian's point, and that's for a different reason. I think he brings out an excellent point, which is we're now used to this asset turnover regime. We've had it for over 10 years. We're used to how it works to a large part. And to bring in a new solution to something which can be easily perhaps tweaked, maybe will allow parties to live in a world where there is a lot more legal certainty and a lot less sort of fear that they are going to end up doing gun jumping or failure to notify the CCI. Because if you look at, again, going back to Facebook, WhatsApp, the response by a lot of jurisdictions was to come out with new thresholds, which allows them to scrutinize such transactions. Now, it was a response. It was a lot of the debate around it. The trigger was the Facebook, WhatsApp merger. Comes then the Austrian version of it, which is a deal value threshold. And then comes Facebook again, Facebook was fined 9.7 million by the Austrian authorities because they did not notify the Giphy merger. So what it comes down to is compliance. What I think Roshan was saying, there is a very effective system already working. And that system parties are now used to. They have great respect and great confidence that their transactions will be scrutinized and be out of the regulatory approval stage very quickly. And to give them, to perhaps come out with a new tool altogether, like a deal value threshold, may be problematic and may concern the fact that whether I need to notify, don't notify, and so on and so forth. So perhaps the answer lies with a simpler solution. Does not need an amendment of the law to take place and go through Parliament, and still empower the Commission. And nobody's taking away that power, because there's a great confidence in the Commission that even if I have to notify my transaction, that transaction will go through swiftly. So maybe that is perhaps the right solution, rather than coming out with fancy, share of supply in the market share thresholds or DVT thresholds, which will create uncertainty and lead to friction.
Mr. Govil, the CLRC had actually recommended the DVT as an additional threshold to enable CCI to access combinations in digital markets, right? So where are we on that?
Yeah, thank you so much. So this question of having an additional threshold for M&A basically came about because certain mergers in the digital sector were not captured and were slipping out from the regulatory scrutiny. And these, we have an internal estimate, not much, but there are not many in such transactions which have come out. But anyway, these are transactions which have escaped regulatory scrutiny. So in this context, the CLRC had made a recommendation to have deal value threshold as an additional threshold. This new threshold will be accounting for an objective quantifiable standards for computing the necessary framework. And also we will be also looking at the local nexus criteria. So this issue is under consideration at an appropriate level at the legislative phase. And and the good news is that legislative process is a consultative process, and whenever the lawmakers make a law, they always seek opinions of the commission and of the government and all other stakeholders also before enacting the law. So many of these issues have come up, and these concerns have also been brought up before the law. So let's see how it pans out in the future. So still it is under consideration and in the realm of possibilities.
Mr. Subramaniam and Roshan, I'll come to the other point, which is gun jumping, which is becoming a pretty strong and debatable hot topic. Many would argue that this happens due to a lack of complete clarity or lack of awareness regarding notifiability of a transaction. Would you agree, Roshan?
Actually, if I may speak to the DVT point that Mr. Goel brought up. So I think the challenge that industry will probably have is valuation is more an art than a science, right? So you can have a situation where, like the saying goes, one man's trash is another man's treasure. So one person says a company is worth so much, valued at so much, when the next person says it's not. They may be similarly placed buyers, buying the same asset, but have different valuations attributed to it. And as a result, one triggers a threshold and the other doesn't. Similarly, what constitutes deal value? Deal value, if I'm looking at it as a transactional lawyer, there's an initial payment, there's a deferred payment, there are holdbacks, there are escrows, there are earnouts for future performance. Now, what all do I take into consideration when determining, and coming to the gun jumping point, do I come up to you and ask for that? Because most of it is going to be points or components which are in flux, which may not be able to be determined upfront. So now how do we land at a clear, cogent criteria that industry is able to understand and say, yes, this is going to be triggering my obligation to come to the authority?
So I may just join.
Yeah, sure.
Actually, a low market share could still result in very high deal value, which had nothing to affect the consumer and the markets. It's just because of the nature of the product pricing, and the profitability that an acquirer, he puts it in a model. How do you value? One is, Roshan's point of view, how do you calculate? But that's a procedural aspect. How do you fundamentally arrive at a deal value? You take cash flows, okay? Or you take, let's say, new growth assumptions, and you build it into an Excel sheet and come to a valuation. And you discount it by a certain discount rate, which is reflecting the income stream or the return expectation. And you arrive at the value. Now, that would not probably meet the core objective of CCI to say that does it really affect the consumer, does it create monopoly? Actual deal value could be completely different from causing a problem on this side. That's the only point. Some may, but by and large they may not even be relevant.
Right. But vis-a-vis gun jumping, do you feel it's largely because of lack of clarity?
Yeah, I think there is a little bit of understanding that could be helped. Okay, that I would put it as alignment. I think CCI has done a very good job in terms of trying to understand the realities of the issue. So what happens is that when an acquisition is happening or a merger is happening, there is a valuation, and the acquirer values the asset on a certain business plan that is presented to him. And they also take into account the assumptions given at that time, including market share, including pricing of the product, etc. Now, what is the fear? You need approvals from lenders, you need approval from some contractees, you need approval from regulators, and many industries have industrial regulator also. So this process is a 3 to 6 month process depending on which industry you are. Sometimes it is smaller also. During this time, when the SPA is signed, the fear is that the business plan based on which the valuation was signed up should not be suddenly uprooted or changed by the current management or the board. That is the fear that the investor has. So what it does to cover that is put a few points saying that you will not change dramatically the business plan which you gave to me. You will not suddenly spring up a new strategy which was not intended. You will not spend some obscene amount of investment suddenly in an asset which I have not seen because I have not signed up to this plan. Okay? And suddenly you will not make changes to management, etc., suddenly without my consent. So this is protection measure. I don't think I think there is a line there. It's not so clear that some may try and begin control also. But by and large, I have seen that most deals put this as protection measures. And I think the confusion starts when these protection measures are seen as gun jumping. I think that is where more probably alignment and understanding with the realities of how deal makers do. Remember, the investors spend a hell lot of money before going into a stage of SPA. SPA is the ultimate stage. Now, if they even have a fear that this will not go through the competition law, they will not even approach. Because I have seen investors doing deep study on the competition side before even looking at the company. Because they say that if it's visible that it's not going to go through, they will not even touch it. So they would be most willing to cooperate. I think the gun jumping provisions are the ones where probably a little bit more understanding of the other side could be of very, very, I think, good use. And I've seen that many of them are purely protectional. They have no intentions to jump it, actually.
Roshan, from a new economy point of view?
I am aligned on this because I think this interim operating governance that we call in transactions, right, from the time you sign till you actually close, and in the case here, getting approval, it's important that you preserve the value of the asset. Now, it may not only be negative protection. It may actually need a consultation because you could have a pandemic suddenly pop up in the middle of your deal. How do you work together to ensure that the asset that you bargain for, you're actually getting the same asset at the end of the transaction? You couldn't have started assuming you're buying X and then land up with Y, which is much lesser than what you started out with. So that's, I think, something that the industry will want clarity on. How do you get certainty on what kind of interim operating governance you could work with without being seen as actually taking over control from the other side?
I think one point could be that immediate pricing power and marketing power decisions. That is the key. That's the play for CCI. Those are the areas where the agreement should not probably tinker with. This is my personal thought process. I'm not saying with clear evidence, but I think that given what the objective is, maybe focus should be on that. The rest is about governance, investment risk, and putting fresh money without permissions. Those, I think, are very acceptable in my view. They should not be really violative.
And Avantika, it adds another layer of complexity in IBC cases, right? Because you have to take lender consent. So there's another set of stakeholders that come in, perhaps, adding to the confusion.
No, I would say IBC cases are pretty set now. There was initial confusion, but because it's so regulated, it's been taken care of. But I think what you're also referring to is the situation where you might want to pay advance consideration, which has been some of the jurisprudence on the subject. I think another situation, offer a bank guarantee to pending payments, because you might be acquiring a company that is in need of funds immediately, but pending approval from the commission, it has no access to the money, and that might jeopardize the lender consents that it needs. So that's a specific situation. It has arisen, it could arise in the future. I think another aspect of gun jumping is of on-market purchases, while we are discussing the idea of gun jumping. So whether minority acquisitions or entire acquisitions of the corporation, what happens when you agree or you decide as an opportunistic investor to make a block purchase on the stock exchange or make staggered purchases on the stock exchange? And this is something that has been part of a very major case that went right up to the Supreme Court. Again, borrowing from countries that have jurisprudence on the subject, I think the Commission had come up with a proposed amendment, a rule of derogation, where you could, in certain circumstances, certain very specific identified circumstances, make the application for approval post facto, and pending that approval, as the acquirer, you would not exercise any control over the target. But that law is still in the making. Maybe it'll find some shape in the monsoon session.
Vipul, many would, however, argue that the current penalty provisions are perhaps too soft or too less. It ranges from 0 to a lakh to 200 crores. Wide-ranging discretion. Do you think the industry would, I mean, don't you think the industry would want more clarity on this?
Arijit, before I go into this question, I would like to respond to 2 or 3 points which have been made regarding the connected issues of DVT as well as the standstill obligations. A point has been made by Mr. Ramesh that DVT is also not necessarily best reflective of the value. So there has always been a debate that what should be the relevant threshold, and the best threshold would obviously be the one which filters out the exact transactions which have any likelihood of resulting in an appreciable adverse effect on competition. So going by that, what can be the best threshold? The best threshold can be some sort of market shares itself. There can be a share of market test. It can be modified versions of that. But increasingly, it has been felt that if you go into any threshold which lacks objectivity, it may hurt the business environment even more. Now, if you want to calculate market share, regardless of what the thresholds for notification may be, the first thing which you need to do is you need to define relevant market. It is not that simple an exercise which the parties can do ex ante and based on their estimates come to a conclusion that this transaction is required to be notified or not. So that's a problem. So that is why all sorts of tests which factor in some sort of assessment parameter are generally given away. Now the thing is that what are we using so far? We are using assets and turnover. Out of the values of assets and turnover, I also agree that assets do not necessarily reflect the competition potential. Turnover at least is indicative of the presence of the entity, the extent of presence of an entity. The assets may not even reflect that. But why do we have that? We have those thresholds for their objectivity. Now the idea, the discussions of CLRC have always been on the aspect that we need something to supplement the asset turnover test. Now there the deal value test comes in. In cases where deal value is more or less in sync with the asset value, as was being said, then in that situation, the transaction would be notifiable on either or basis. Because even if we consider the present threshold regime, it would still be notifiable. So what will deal value test actually capture? Deal value test will capture only those situations where deal value is disproportionately high compared to the value of assets or the turnover that particular entity has. So deal value test, if and when it becomes part of the regulatory framework, it is going to be a good addition to the existing thresholds, and it is not going to take anything away from the existing scheme of things. So this is the point which I wanted to make on deal value.
Can I come in here?
Yeah, please.
Arijit, I just want to highlight one thing that deal value or revenue, it will be better probably to look at revenue share in the given market and invest time and money in defining markets properly, okay, based on evidence, of course, rather than straying, I'm using the word probably strongly, but straying into a territory which is clearly going to go wrong in most of the cases. Clearly, deal value will go wrong in most cases because it's nothing to do with market share in by and large, because investors do not look for deal value straight away with market share. They will just look at the market and then say what's the value of the profitability there and then backwork the valuation. That's the only thing. Maybe stay closer to the consumer issue and the market issue and control and dominance issue by putting, if it's revenue, then revenue share would be more relevant than just plain revenue. That's the only point I had.
So we are running out of time. So Vipul, if you could answer the
penalty.
The penalty.
Standstill obligation point. So I'm just making the point on the standstill obligation. And
no, the penalty provisions first, because I asked you whether the penalties were too soft.
On the penalty provision.
Yeah.
But then the problem is that, the range of penalty, the explanation for that lies in the concept of standstill violations. And for that, I'll have to give you a very brief kind of an overview. What happens is that gun jumping is a very broad concept in its own right, and it can take many forms. The first one being that initially there used to be a time when the notice was required to be filed within 30 days of execution of definitive agreements. Now, in that case, if someone has not notified the combination within 30 days, they have notified it on the 31st or 32nd day, there will be a technical violation, so to say. Now you cannot compare this case with someone, which consummates the combination without notifying it at all. So one extreme, just a technical violation, and to the other extreme, someone has consummated without filing the notice at all. Now the third situation comes that the notice has been filed in time, but with the evolving jurisprudence, some issues may be unclear to the parties and they have advertently or inadvertently undertaken certain conduct which is going under the contravention of standstill obligations. Now in this case, the focus may be more on the, educating the stakeholders, more on informing them of the requisite regulatory framework rather than imposition of penalty. So under all these circumstances, the penalties are going to be broad-ranging. So that is why the current range of penalties, which you brought out, is basically to take care of all the various situations which we come across as a part of gun jumping investigations.
Karan, linked to, what Vipul just said about standstill agreements, what additional guardrails would you recommend in this regard?
Guardrails for companies to...
Yeah.
I think the main point is first knowing where you stand, where the law, the legal provisions. A lot of times I must tell you from experience that the M&A lawyers have already made the SPA and then suddenly realized, oh, we may have a filing in India, and you go, filing anywhere in the world, and you may have to go and do that. By that time, you've already hard negotiated those standstill provisions, you've negotiated timelines, long stop dates, and so on and so forth. So it's important is to take this sort of cross-functional approach very early on. The second aspect is understanding what the law, the demands of the law is. We've had, in the last, I would say 2 or 3 years, we've about averaging about 4 or 5 cases of gun jumping every year. And that's not something which is unusual. You see, there's the International Competition Network did a survey and found a lot of other jurisdictions older than India having sort of a similar number of transactions which have been found to be indulging in gun jumping. Now, where does that leave us? It leaves us with a scenario where the CCI's guidance and its precedents, the decisional practice, will be instructive of what has to be done and what doesn't have to be. We spoke about, the standstill provisions, what has to be, whether or not you maintain the status quo of the company between signing and closing. Now that we have the Adani Green case, which is very clear as to what is expected of companies. Equally, if there is the real intention of a transaction is not filed, and the whole, as Mr. Goval was saying, this is a trust-based scenario. If you're not providing the entire information to the CCI, and the CCI finds tomorrow that the information is incomplete, it invalidates your notice, and then you are set with a large fine to deal with. All this means that you have to take those precautions early on, assume the risk that if you don't go to the relevant regulator, you're going to be fined. And from a regulator's perspective, this is something Ukraine used to have this really low thresholds, which every transaction in India had to be filed there. Austria, Germany used to have similar. But what they came out with was realization that we still want to know what has changed in the economy, what are the structures of the market that have changed. So they came out with an amnesty scheme. We will not fine you, but come and tell us what the transaction is about. So those are sort of things where there could be confidence building on both sides and a more understanding of how the law operates.
You talked about the Adani Green SB Energy case, but there one can argue that it became evident that there are no legislative or precedential bright line and exhaustive tests in India to definitively reach a conclusion.
So Ajit, I think there's globalization of competition law. The rules don't really. The rules change country to country. The competition assessment changes country to country. But predominantly, what we have here in India is not so different what you'll have in Singapore or in Korea or in the UK. So it's not to say that that what the CCI did in Adani Green was something novel. And in fact, there is enough literature in the International Competition Network as well, which talks about these issues and why competition authorities have issues with them, because it could lead to softening of competition. Imagine a scenario where companies have softly integrated in this manner and the transaction breaks. But by that time, information flows have taken place. Control has taken place, which would lead to that even if they were to go back to the original scenario where they would still be competitors of each other, the competition would have softened, and I would have already revealed my cards to my competitor, which I would have otherwise not done so.
Understood.
Can I just add one more point? Sorry, just to... I think there is still a lot of room for, I think we were going back to private equity. Even if you look at the sort of the current decisions on gun jumping, we have seen that there could be some, and we've been working very closely with the combination divisions to asking for those guidance. Lawyers thrive when there is gray. But here, I think for the larger perspective, which is that some guidance on how do we calculate thresholds, do controlled entities come within the ambit or not, are all things where we're looking for guidance from the CCI, and I'm sure that will come soon.
Ram, if we talk about vertical and horizontal merger, I want to understand from you, what's the theory of harm when one considers vertical mergers?
Okay. Vertical mergers are basically transactions between two parties in a value chain.
Yeah.
And just an easy example, between a supplier of inputs with the person who is buying those inputs. So there are, I think Vipul alluded to it, there is the big issue of foreclosure of markets.
Yeah.
So if there are multiple entities buying that input and one of the buyers acquires the input producer, then there could be a situation where the input is not available to others in the marketplace because, they are competing entities and the person who's acquiring the supplier of the input is basically foreclosing the market to the others. That is one concern. The other concern is something which is, very, the EU law talks a lot about it. It's called margin squeeze. Mm-hmm. It's the same concept that, if there are two entities which are competing with each other, but one entity goes and buys the input producer, and now it is able to reduce its price because for the final product, because it's now acquired a supplier of the input, and there are no double margins associated with it, then the other competitor gets squeezed out of the market, right? To my knowledge, the lawyers would be able to clarify. There is no margin squeeze in Section 4, which is the abuse of dominance section per se, but it is something that you need to be concerned about when you're looking at a vertical merger.
But then, Mr. Govill, are horizontal mergers much more problematic? I mean, I'm asking this because, as I said, as a layman or as a media person, there is a perception that there are some conglomerates who are creating monopolies. Adani's in port, in airports. In fact, in some cases, they are also buying ports through which brands or commodities they themselves market also passes through. So it's both vertical and horizontal. So there is a perception issue that's getting created here.
Thank you so much. I think I can put up this question in another way, that there is a perception that somehow competition agencies can either create national champions or can stop them from being in place. So that is the perception, that it is somehow with the competition agency. What we do is we do not, when a case comes to us, we would then assess it on the facts of it. For example, it is an acquisition of a port or an acquisition of an airport. We look at the transaction at that stage. So over there we do a assessment, and that assessment is done on the framework. So sometimes that assessment is different from what could be perceived by people, that so many ports are acquired, but actually there is no horizontal problem because there are other ports in the which are what you call addressing the same hinterland, or which are in the same hinterland, or which are giving competitive constraints. Or there are certain terminals which are there. Like, for example, in this case, in Chennai, there were some terminals owned by the Singapore port or by the Dubai port, which have got additional, advantages for pricing, etc. So these type of issues are there. So we would generally consider those issues which are on the table when a merger comes for assessment before us. So that is why sometimes I would not like say in this market versus that market whether horizontal issues are more important or vertical. Vertical issues will be important because in the same supply chain, suppose there is a vertical integration where the port and the other facilities. So basically it comes out to be competition for the market. The port in itself is a market, natural monopoly in itself, but within that, whether the services which are provided are competitive or not. So that is the issue in question in those cases. So we cannot say whether horizontal are more important or vertical are important. Both needs to be assessed, and that's what we do. Even we look at complementarities also.
Okay. Roshan, I mean, Byju's also, as I asked you before, that you've acquired several companies. Some, one may argue, would be vertical, some would argue be horizontal, amalgamation, so to speak. What's your
I wish I was better placed to answer it as a humble lawyer. I don't really have an answer for you on this. But, like I said, we welcome assessment where it's appropriate, where we think that, there is an impact. Happy to participate and be transparent.
Avantika, do you expect our antitrust authority to be a hipster antitrust authority? Should it go beyond its remit and jump in when it comes to environmental efficiency? Because ESG is increasingly becoming issues. It's strictly not its remit, but should it be one?
In this case, I don't think it matters what I think. So if you're asking me to crystal ball gaze and tell you whether the commission will be hipster, no, I don't think it will.
Should it?
Look, if I can speak for what I see, if the commission is confronted with the question of environmental issues, maybe environmental innovation or a killer acquisition in the environmental space, then purely based on the impact on markets and competition, if the commission has jurisdiction, then it will intervene. And I think that is a reasonable position to be in, because just looking at the international discourse on ESG generally, one finds that the exception to my mind was Germany, which suddenly has a hands-off position on ESG, but they were very keen to regulate data, which arguably is not a competition, directly a competition or antitrust issue. So I think if the commission is confronted with a transaction or a situation where it already has jurisdiction, then it may consider consumer preferences or thresholds where environmental efficiencies become relevant. But will they jump into every situation in the presence of various environmental regulators in the country? I don't think so.
So just to add to it, what really is the issue on table is that competition issue has got intersection with a lot of other issues. For example, privacy, data, etc. And a lot of times antitrust authorities are asked to intervene in those areas. And that is something which we need to treat carefully, as to we do not assume what is not in our jurisdiction. And we should not go beyond what is there. But yes, in the case where there is an abuse of dominance, where a player is dominant and when it is using its dominance to bring about changes in privacy, which we may have seen in some of the cases, that is the place where we may need to intervene. And as far as these environment issues are coming, they are coming in a big way. And I think we will be following the same policy which we have been following in the other spheres also, where there is an intersection between different policy alternatives. Yeah.
The green, yeah, please.
So I think I think generally when you look at ESG issues, right, they come under the broad aspect of innovation. Should the commission go in because someone dumped oil into the sea? No, that's for the NGT and for the others to do so. There's the complete direct framework. But if there is an acquisition, like I think I was saying, a killer acquisition, which is going to prevent innovation from coming to the market, that is clearly within the domain of the commission. So it's a question about whether these get scrutinized, when do they get scrutinized, and if they don't, are there any exclusionary conduct subsequently which can be caught under Section 3 and 4? Mm-hmm. So in the wider remit, whether it's technology, whether it's ESG, otherwise, the CCI does have this overall jurisdiction, but within the jurisdiction granted by the legislation to it.
The last question I have before we open the floor to, this panel for questions from the public is to Vipul, the fact that, the Green Channel is certainly a laudable move, because I don't think anywhere else in the world clearances this fast are happening in the same day. However, some would argue that the application of that has led to some inconsistencies, such as in airports, for example. Is the Green Channel going to be available to multiple or repeat investments in the same sector?
I think I can take this.
Sure.
See, the basic point one need to understand why we have introduced Green Channel. Green Channel is not something to do with notifiability. For that, there is a Schedule 1. So any transaction which breaches that threshold of combined asset and turnover, that has to be notified. Now, and it should not be exempted either under the de minimis or Schedule 1. That needs to be notified. Now, the point about Green Channel is regarding overlaps, and that has to do with risk. So we have carved out a category of notifiable transactions. So these transactions are notifiable, but these are sort of low-risk transactions. It is the same principle which we use in the airport. So basically, being from the customs background, I understand what Green Channel works. Is we have low-risk passengers, those who are coming and tourists who don't declare. They just move out of the Green Channel. The same is over here, low risk. You self-assess and declare that there is no overlap, so there are no concerns. So those are the transactions which come under the Green Channel. So we will not be looking at from the market share point of view. These Green Channel, like for example, additional overlaps. So what we are looking at is whether there are overlaps or not. That is the and which
why
is
I'm asking this, Manish, is because again, two very large conglomerates. In Tata's case, I think you disallowed, you wanted certain changes, but then one would argue in Adani's a lot of greenfield projects were approved. So that led to a lot of debate.
Yeah, I think there's some sort of a
There was a GMR
yeah. So that is the commission had allowed. The commission had allowed the transaction, but there were certain concerns, and they were asked, and some voluntary remedies. Some voluntary remedies were given by the parties, and subject to that, it was allowed. But it was not because of the commission. I think the parties on their own had not gone ahead with that transaction. So those remedies have not been implemented because the transaction did not take place. In other case, again, it's a case of a horizontal merger where there are no overlaps. So if there is one airport in India, one airport in France, so they are not competing with each other. Every airport is a single airport, and it's just investment. So in that case, where there is no overlap, then we don't see the size of the transaction. It is just whether there is no overlap or not. So that is the case. So each case has to be seen in the right perspective. You cannot compare them.
Okay, understood. But let's now, open this panel to questions. So if anyone has any, please identify yourself and direct the question to anyone in the panel.
I think everybody is tired. Afternoon session. Not much energy. Yes, Aparna is. Yeah, please.
Thank you. I actually don't have a question, but I just want to understand something, and I think that's something we need guidance as an industry. Sorry. My name is Aparna. I'm a partner with Shardul Amarchand. I think item 1, which is our minority shareholder exemption, which is available to private equity, that was an issue which was discussed by the panel. And I think the panel left with very valuable points on at what stage we need to see a private equity as a passive player and then see a private equity as a strategic player. And keeping that aspect in mind, I think as stakeholders, speaking on behalf of private equity players and clients, there is a need of guidance to understand at what stage for notifiability, whether that one board seat is being viewed as control, and at what stage then genuinely it is a control which that private equity is exercising. We understand that when that board seat is coupled with veto rights, may change the color and the flavor. So I think that is where guidance is needed, whether through, orders or through revision of FAQs, that will be helpful.
Yeah, thanks, Aparna. That's a pertinent point which you have made. In fact, we have the benefit of, in fact, it's a commission which had the benefit of looking at a lot of gun jumping cases in the recent past, and sort of a clarity has come out with us, and we have come out with the decisions, certain decisions recently on 43A. We will also be coming out with FAQs, and that is something which has been, even the Honorable Finance Minister has told us to come out with FAQs on these issues. So I think we'll get the clarity over there. So just now it's not right to really give you what the idea is. We can speak separately on this too.
Mr. Srinivasan, you want to ask? Or okay. I think no other questions, so request Manish to sum up our session. Lots of points, I know.
Thank you, Arijit. And respected Chair, Mr. Bishnoi, my fellow panelists and dear friends, I think it is a very, very difficult point to sum up this panel because a lot of points have been touched on. We started with a discussion on notifiability of minority acquisition and strategic investment. Then we went ahead and discussed about digital mergers. A lot of issues were discussed in the digital mergers regarding the assessment framework, what are the challenges in the assessment framework. We also dealt with small target mergers and deal value thresholds, and we got the benefit from getting the views from the industry, both from the brick and mortar side and also from the digital side on small target exemption and the desirability of having to introduce an additional threshold, which is regarding deal value threshold. After that, we had a long discussion on vertical mergers and supply chains. And here also, the Commission's practices were discussed. And we also discussed about standstill obligation and gum jumping, And very, very interesting, this is for the first time this issue came about hipster antitrust. So that was also an issue. I think this is something which is debated in the US also. Recently they have spoken about antitrust involvement in the employment side, labor market side. So some non-compete clauses were entered into in the labor market. So whether the antitrust authorities should be looking at these or not. And that has been a very, very interesting discussion, I must say, a lot of new issues. And just a point which I want to make is about the digital markets. There is a sort of concern in the digital market as more of this market. Because what is the digital market? The digital market is a market which is created by a lot of people. There are people like Arijit who produces news, there are artists, there are musicians, there are technicians, engineers, computer people. They are a community of people who have created this digital space, and they interact with each other on the basis of trust and collaboration. On the other hand, it is the corporates which rule over the digital space, and every time you enter into a website, you enter into a contract. So it is more about contracts. And when those contracts are when those contracts are broken, or not even broken, or sometimes inadvertently those happens, they have got huge muscle power, and they bring you in the courts, and so there is a lot of conflict, and which leads to what is this antitrust. So really in the digital market, as each of us is a stakeholder in this market, we have to see that these markets are democratic. We have to move from conflict to what you call collaboration, from contracts to community work, and from antitrust to trust. So that's how we'll have a more vibrant So we have to keep the basic objective, and I think that has something which came out in the last discussion also. So our antitrust analysis in the digital market should be grounded in the realities, and not only the realities of the antitrust frame, it should be grounded in the reality, in the Indian realities, in the context of the Indian realities. So that's all. I would not take much of your time, and I would thank all the participants who have come here and heard us patiently on a Saturday afternoon. And I would thank...
after lunch.
After lunch. Thank you so much.
Mr. Bishnoi, if you could deliver the vote of thanks and your closing remarks, sir.
Thank you, Arijit. My closing remarks will be in the nature of a vote of thanks. I will first begin by thanking you for so ably steering our discussions today. I can say with certainty and confidence that our discussions would not have had the richness that they had if you had not guided us so ably. So thank you very much, Mr. Burman. We are indeed grateful to you.
Thank you, sir.
Mr. Chandiok, the Commission knows you well and holds you in esteem. I thank you for your inputs on what is happening in other jurisdictions, on deal value threshold for notification, and also on ESG. Your inputs will be most useful to us. I come to Ms. Avantika Kakkar, who represents a number of clients before the Commission. I would first like to assure her that what she thinks definitely matters to the Commission. So we are most appreciative of the thoughts you have shared with us on common ownership and minority acquisitions, on innovation theory of harm, and ESG. Thank you very much. Mr. Ramesh Subramaniam, you have brought the business perspective to us. That is particularly valuable. We have taken note of what you've said on minority acquisitions, small target exemptions, and investment protection measures. We will certainly take your perspectives into account. Mr. Roshan Thomas, you are the go-to person for insights on mergers in the digital space. Thank you very much for sharing your experience with the CCI. You've done a great deal of advocacy for us today, so thank you very much. We've also taken note of your thoughts on gun jumping and the perspective of startups. Dr. Ram Tamara, you have valuable and vast research experience, which you have kindly shared with us today. We carry away with us many important perspectives that you have shared, particularly on vertical mergers and supply chains, competition assessment in digital markets, and killer acquisitions. Last but not the least, my two dear colleagues from the Commission, Advisor Manish Goval and Joint Director Vipul Puri. They are the very pillars of the regulatory functions we carry out in our combination division. I'm happy that apart from being enriched by the perspectives of other panelists, you have also been able to bring our viewpoint to the gathering. Distinguished panelists, esteemed guests, markets are dynamic and so should be regulation. It is only through sessions like this that the regulator can be abreast of new developments. It is, in our view, extremely important for us to consult industry and all other stakeholders in such a manner. I hope this session has been useful to the panelists and to people in the audience. It has certainly been so for the Commission. And I thank you very much on behalf of the organization. I thank you all.
Thank you, sir. May I now request to kindly present the mementos to our distinguished panelists as a token of our appreciation. Request you, sir, to present the memento to Mr. Karan Singh Chandyok, partner Chandyok and Mahajan. To Ms. Avantika Kakkar, partner Cyril Amarchand Mangaldas. To Mr. Ramesh Subramaniam, Senior Vice President, Tata Sons. Mr. Roshan Thomas, Group General Counsel, Byju's. Dr. Ramji Tamara, Senior Economist, Econ1 Research LLC. We conclude the session with a group photograph of the panelists. So we request all of you to please step back for a group photo, or stand up maybe, just here. I think you can. I'm so sorry, Sir, Mr. Arijit Burman. I forgot to take his name. We have to present the memento to Mr. Arijit Burman, who's the moderator of our session. Ladies and gentlemen, please give him a big hand.